Welcome to this free immigration help channel. Today is June 27, 2023, and we are getting into the volume 127 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, before beginning this video, I'm gonna mention, as I mention in every video, I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS, and of course the Department of State with their visa bulletin. So let's start with the very first comment from Crystal USA Bio 7150. Hi, I'm from Philippines. My priority date is February 2015 and I am documentarily qualified last 2022. You think when is the possible interview? I hope you answer my question. Thank you and God bless. And also another comment from Crystal mentioning that she is in family sponsor preference F1. Crystal, thank you very much for your question. Let's take a look at the visa bulletin and see what's going on. I know Philippines, they have a separate chargeability area, so let's see what they have for F1. Since you are already documentarily qualified, we need to just look at the graph A. We don't need to look at the graph B. So F1, Philippines, looks like March 2012 is the priority date. So people with priority dates on or around March 2012, as of right now, June, July 2023, their immigrant visas are becoming available. And you are in, let's see, your priority date is in February 2015. So you are looking roughly at another 3 years before the availability of the immigrant visa. I am honestly surprised that they documentarily qualified you a little bit earlier. Maybe, you know, since they documentarily qualified you earlier, maybe there will be a good move on the visa bulletin for specifically for the Philippines, because usually they documentarily qualify people a year and a half, 2 years max usually before the availability of the immigrant visa. And they documentarily qualified you in 2022. This, let's see, no, you didn't put the month. So 2022, so that is, let's see, you still have 3 years, about 4 years before the availability of the immigrant visa. So we will see. I would recommend staying on top of the visa bulletin, checking it every month. I do here on this channel, every month the new visa bulletin comes out. I make a separate video on it and discuss all of the categories, all of the chargeability areas, and compare it to the previous visa bulletin issue. So make sure to subscribe if you're not subscribed yet. But as of right now, looking at the visa bulletin, as of right now, you roughly have another 3 years for the availability of the immigrant visa. So let me post a response here, as well as here, since you posted 2 comments. And we're gonna move on to the next question from Celia Mena 665. What happens when you haven't received your welcome letter and it's been more than 2 months? Okay, so 2 months, so you're current on the graph B and you still have not received your welcome letter. I would recommend definitely submitting a public inquiry with the NVC and following up and asking and telling them that, hey, you know, I'm current on the graph B on the visa bulletin and I still, you know, my NVC portal is still locked. So I was wondering what's going on. So I will show you how to find that public inquiry form. You can find it on the travel.state.gov, which is the official government website for the Department of State, Bureau of Consular Affairs. This is their visa bulletin page, and you can find this page, the link for this page, in the description of this video. So click on that link for the visa bulletin. You will have this page in front of you. From this page, you will click on Contact Us right here at the very top. I'm gonna open it in a new tab. And sometimes it takes, for some reason, there you go. So we're gonna click on US Visas Contacts right here. I'm gonna click on this, and then you'll scroll down a little bit, and in the very first row of this table, you will see email public inquiry form right here. So we're gonna click on public inquiry form. You'll scroll down a little bit more, and then you will see online immigrant visa inquiries only public inquiry form. So we're gonna click on this. And this will give you the public inquiry form that you need to fill out. So you will put your, if you have your NVC case number already, you will put your case number. If you don't, you can put your USCIS receipt number from the original I-130 that was filed. Principal applicants full name is going to be beneficiary's full name. Principal's applicant date of birth is going to be beneficiary's date of birth. Petitioner's full name, who you are, petitioner or principal applicant, beneficiary. Email address, and then in your inquiry you can type in, introduce yourself a little bit, give a little bit more details about your case, explain that you are current on the graph B of the visa bulletin. Your priority date is current, meaning that the NVC portal should be already opening up, but it's still not, and then submit it. Usually they are pretty quick with their responses to this public inquiry form. 2 months, I would say it's definitely time to submit this public inquiry because it's weird. However, I want you to note one thing is that since we had this movement on July 2023 visa bulletin, specifically, I think it was for F1 category, if I remember correctly, there was actually a movement for one of the categories, and I'm pretty sure it was F1 for graph B, and a lot of people became current according to the visa bulletin, but their NVC portals are still locked. And I've received quite a few comments, quite a few questions about it on this channel already. So I think somebody might have a little bit messed up with the visa bulletin, or they somehow, I don't know, didn't take into consideration some of the cases, or they didn't get to certain cases and didn't open up the portals. So there is something going on, which means that we really need to take a look at the August visa bulletin before making any kind of rush decision and, becoming nervous, because you might go back to where it was before on August if it was a mistake. But we will see with the new issue of the visa bulletin. Again, if you're not subscribed, make sure to subscribe to this channel, because every month I do a new visa bulletin video. Okay, let's move on to the next question comment from Stephen Benny 4143. My wife's I-485 was denied because we did not provide her birth certificate in foreign language. They gave us the option to reopen or reconsider. I filled out I-290B to reopen the case and provided the birth certificate with it. Excellent. I attached the explanation why we did not provide the birth certificate in the foreign language in the first place. Perfect. I received a notice from USCIS that they received the paperwork and they are reviewing. Her case was sent to Missouri. Awesome. My wife's visa is expiring in September. Do you know if she can stay here or it's better for her to leave the US until I-485 is approved? Please advise. Stephen, thank you very much. That's an excellent question, and looks like you've taken care of the issue that came up just perfectly. You did it great. So regarding your wife's visa, I don't know what kind of visa that she is currently on right now here in the US, but I will assume for the purposes of this video is that it's non-immigrant visa, something like B1, B2, or maybe a student visa, something along those lines. So if you want her to remain in the country, you have to make sure that she maintains the legal duration of stay, the legal status in the country of a non-immigrant. So another easy thing that you can do, I mean, you already taken care of, a pretty complicated process, I would say. So, and you did it great. So just submit the I-539, and that's the application to extend or change the status. You're not going to be changing the status. You're going to be extending her duration of stay. And these I-539 applications, as of right now, they take quite a long time to be reviewed. I think it's like 13 months. They're just pending in USCIS. So while the petition is pending, she can remain legally here in the country without any problems, and hopefully by that time her I-485, the motion to reopen the case is already reviewed, and they take a look at the documents that you submitted, the explanation, and they say, okay, now it's good, and they approve it. By that time, I think within a year that should definitely happen, because usually these motions to reopen, they take about 6 months max, especially with cases like I-485, especially with this very, I would say, simple reason, because it's really just there isn't really any issue with the case. It was just the document that was missing, and it's not even the document that was missing, it's a translation of the document that was missing. So I think it's going to be reviewed pretty quickly, but yes, absolutely, you have to make sure that she maintains the legal duration of stay in the country, legal status. So if it is a non-immigrant visa that she has right now, I-539. In fact, I will find it on USCIS and I will paste it in my comments so you have it. And you know what, let me do the brief navigation demonstration for everyone who's watching this video. This is a USCIS.gov official government website for US citizenship and immigration services. Whenever it comes to immigration petitions, really any kind of immigration related information, this is it. This is the main source. So this is what the front page looks like. You can find this link in the description of this video. Just click on forms right here at the very top of the navigation menu, forms. And then all forms right here, this page right here. I'm going to click on this and it will give you all of the forms that are available, all the immigration petitions. So you can scroll down, it's an alphabetic numerical order, or just type in 539, search, and there you go. Application to extend, change non-immigrant status. So you're extending the status and you can file this form online, so it's pretty straightforward. So let me paste my response here and I'll paste the link so that it's more convenient for you, and I'll copy this thing back. And we're gonna move on to the next comment from Nika R12. This is really helpful. Just wanted to ask, my petitioner became a citizen. Okay, so US citizen 6 years after our petition was filed. Now it is still showing F24, which is the subcategory of the F2A. F24 is the children, unmarried children of permanent resident in our visa class, and is now documentarily qualified and now waiting for an interview. They thought the lawyer then was able to take care of this by informing NVC should this be an issue during the interview. Hoping we can get insight regarding this. Thank you. Okay, Nika, thank you very much for the question. Sorry that you are, another example of the lawyer recklessness, or whatever it's called, negligence. That's the word. Negligence. It's sad, really, because they should have taken. I mean, it's been became citizen 6 years after our petition filed. I'm assuming it happened pretty recently, and because F2A cases, they really usually don't take that long. In fact, I'm thinking you might be, I'm not sure if you're in old chargeability area, you might be one of those chargeability areas that takes a little bit longer, because it's quite a long time for in general, in F2A category, permanent resident. But here's the thing, since you are already documentarily qualified, the only thing that is left is now the interview. So it's really no point to change between F2A and F1 right now. It doesn't really make, I'm sorry, not the F2A, F2B. That's the category, or F2B, subcategory of F2B, F24. But it really doesn't make much of sense to switch it to F1, because you're already documentarily qualified and now you're just waiting for an interview. There isn't really much difference. But for the purposes of, once you go to the US Embassy for an interview itself, for the purpose of the immigrant visa interview, you want to make sure that they are updated and that they know that the petitioner is now US citizen, just to be on the safe side, just so that there is no extra questions like, hey, why didn't you guys inform us, or whatever, even though usually they are the ones who know first and they are the ones who send you an option to switch from F2 category to F1 category when the petitioner becomes US citizen. So really, I would recommend just submitting a public inquiry form with the NVC and just letting them know in the inquiry that the petitioner is now a US citizen, that you don't have any plans of switching from F2 to the F1, but just for their for the purposes of them knowing the most updated information about the case. This is it, and then you can attach the naturalization certificate of your petitioner. And that's really it. And they should be aware of this. I mean, they probably are aware of it right now, but just to be on the safe side, I don't know why your attorney didn't update them themselves, but do it yourself. Stay on top of your case, which looks like you do. And I'm gonna copy this public inquiry form in here, and you should be good to go. Again, there is really no point of switching right now from F2 to F1, but for the purposes of them being updated about your case, to be on the safe side, I would recommend submitting the public inquiry form and updating them. Okay, let's move on to the next one from Denise 24958. Denise, thank you very much for another comment. This icon right here means Denise is one of the top commenters. So Denise says, Hi sir, my priority date is current. I'm waiting for NVC to open the portal for me. I sent an email, yet no reply from them yet. It's been 6 years now in the F11 category, which is subcategory of F1. What could be the cause of this? So Denise, you're one of the people that I think got affected by and definitely it's F1. Thank you for commenting and reminding me. It's definitely the F1 that changed significantly from June visa bulletin to July visa bulletin. And a lot of people on the graph B for F1 category, they became current. They became current, but their NVC portals are still closed. So that tells me that either, I'm not sure honestly what happened, because maybe they kind of jumped the gun updating the July visa bulletin, because, you're not the first one. You're already the second person just in this video who commented on this, and I had probably another at least 5-6 people who commented and said the same thing, that they are current on the graph B as of July visa bulletin in F1 category, and their NVC portals are still locked. So that tells me that there is something that is going on. Maybe a problem with visa bulletin, maybe the problem on the NVC side, but it will be a little bit easier to tell with the next issue of the visa bulletin. So if you have not submitted, I don't know how you send the email, if it's the public inquiry form, they didn't respond, then I would recommend submitting another public inquiry form. I'll copy this link right here. Submit the public inquiry form through this. Don't send a separate email, because they don't check the emails, but they always check this, and they're very quick to respond with it. And if they do respond and it's a generic response, then really we just have to wait up until the new issue of the visa bulletin, and August, that is August 2023, and take a look at that and see what's going on with this, with the F1 in the graph B, because after them receiving all of these public inquiries from F1 applicants who are current on the graph B and the NVC portals are locked, if there was an issue with an update on the visa bulletin, they should update it in the next issue. But if not, then your NVC portal should be opening up anytime now. Really, maybe that's really what is going to happen. We'll just wait a little bit more, and it opens up. So submit the public inquiry form, and then let me know, please, what they respond to it. Okay, let's move on to the next comment from Harpreet Kaur 1706. Gross income is matters in this, or income after all the expenses. In affidavit of support, we pay tax after all the expenses, and left amount is considered in affidavit of support, or our gross income in a year matters. I appreciate your reply. Great question. Thank you for asking. So yes, it is definitely gross income. All the income that is before all of the expenses, right? So let's say, you earned in a year $50,000, and let's say you had $20,000 worth of expenses. Maybe if you're for example a business owner, and you had your driving expenses, your tools, your something, whatever, and you have left net income of $30,000. So when you're applying for stuff like loans or whatever, you're showing the net income, yes. But whenever it comes to immigration purposes, affidavit of support, you are showing the gross income, the original $50,000, the whole amount that came in. Great question. Thank you for asking. Okay, let's move on to the next question from Fidara Fidudusola 4045. If I have an approved petition from the US and the visa category is not available, can I apply for F1 visa? What are the chances of getting F1 visa approved? How do I defend the F1 visa at the embassy? So I'm assuming you're asking, I'm assuming you have the family reunification petition. Somebody filed for you, a petitioner in the US, and the immigrant visa is still not available. So you're thinking about applying for a non-immigrant visa, F1 student visa. And you're asking if there are chances of you being approved. Absolutely 100% yes. And in fact, I would recommend doing it to everyone who is watching this video and who has a family reunification petition pending, and their immigrant visas, their priority dates are not current, and they will be waiting. I would recommend in the meantime trying to get yourself a regular non-immigrant visa, B1, B2, J1, F1, whatever it is that, whatever it is, if you want to come here and study for, maybe work on your English skills, find an ESL program and get yourself an F1. Maybe you can get yourself an exchange program and come here on J1. Or maybe you just want to visit your family, check out the country, because, hey, eventually you're planning to immigrate here. So there's nothing wrong with it. It's a great idea. And if it works out, it's fantastic. Keep in mind that sometimes it's not even the embassies. It's the people, it's the whatever you want to call them, consuls, whoever take the interview. Sometimes they are, I don't have a good polite word for it, but sometimes they are on their not very good day. Maybe they didn't have a good day sometimes, or whatever. They can use your petition that is pending, your immigration petition that is pending, as a reason to deny your non-immigrant visa application by saying that, hey, you have an immigration petition, so you have plans to immigrate to the United States, and now you're applying for a non-immigrant visa, so it's going to be denied because you have plans to immigrate. It's not fair, and honestly, I believe that it should be brought to the attention a little bit higher up, Department of Homeland Security, Department of State, U.S. Congress, because that should be prohibited. They shouldn't be able to deny based on some other petition that is pending, that is going to be pending for another 10 years, whatever, 5 years, something completely separate. In fact, they should be more lenient to give them a non-immigrant visa so that they come here, because it's better for everyone. It's better for the country. It's better for these prospective immigrants that will eventually immigrate here, because by coming here on a non-immigrant visa, they will be able to familiarize themselves with what the country, how it is, how the things are here. If they come here on a student visa, even better. They will study, they will learn some English, even better, right? So it's good for everyone. But still be prepared that they might deny your non-immigrant visa request, because I've seen it personally myself, and I've seen, some of the people who are commenting on this channel, they've been denied for that reason. So keep that in mind. Don't be discouraged by it. If you are denied, there's always an option to try a different U.S. embassy and go through the interview there instead. Or, for example, try a different visa class instead of the F1, because F1, if you think about it, F1 takes a little bit more investment in order to get the, to apply and get the non-immigrant visa, because you have to pay for tuition, you have to be enrolled in the university or the courses or whatever it is. But B1, B2, there is nothing like that. You just go there and you ask for a non-immigrant visa, and that's really it. So here's a few options for you. Hopefully my answer was helpful. Okay, let's move on to the next question from Shabana Khan. I am from Guyana. I think that's how I say Guyana. Oh. My priority date is September 28, 2017, F11, so subcategory F1, unmarried daughter, chargeability. So chargeability area is Guyana, so all chargeability area. 01 January 2017 is the priority date, I'm assuming. No, the priority is September 2018. Answers from 126. Okay, Shabana, thank you for your follow-up. I really appreciate it. So let's take a look at the visa bulletin and see what's going on for F1. F1 with the priority date in September 2017. So we're going to take a look at the graph A, F1. So right now we are on December 2014 for all chargeability. That means you're about 3 years away from the availability of the immigrant visa. So let's scroll down to the graph B. Okay, so you're on September 2017, and looks like the NVC portals are right now opening up for September 2017. So if your NVC portal is not open yet, it should be opening up anytime now, and you should be able to start your documentary qualification process, DQ process, basically, very, very soon. I would highly recommend checking out the video that I have on this channel. It's called Documentarily Qualified. What does it mean? I think I think that's what the video is called. I'm very sorry. I'm really bad memory. Documentarily qualified. That's how the name of the video starts. Check it out. In that video, and that goes for everyone. If you're not documentarily qualified yet, check out the video. In that video, I mean, I show the real NVC portal that was already documentarily qualified, and you can see exactly how it looks like, what documents you need to provide, what you need to fill out, what fees you need to pay. So if you're prepared before the NVC portal opens up, once it opens up, you have everything ready, you just submit it within a few days. That's it. You documentarily qualified, hopefully in a few months, and that's it. You just wait for the availability of the immigrant visa. But Sharbana, you're really, really close to the NVC portal opening up, if it's not open yet, and then you're looking roughly at another 3 years for the availability of the immigrant visa. Okay, let's move on to the next question from Tony McDonald, 2596. Would you say for B chart F2B applicant that submitted their application in 2018 have a year? All right, let's take a look at a graph B. F2B, I'm assuming that's all chargeability area, so F2B. Graph B, that's it, that's what we're looking at. So January 2017, 2018, yes, absolutely. Yeah, you're correct. Yes, your estimation is correct. I would say about a year. About a year for the NVC portal to open up so that the applicant can start the documentarily qualification process. But for the actual immigrant visa, then we're looking at the graph A, and then it's roughly a little bit less than 3 years. I would say like 2.5 years for the actual availability of the immigrant visa. Okay, let me pause this right here. And we're going to move on to the next comment question from Anahi559. If you don't have your COVID vaccination, you can apply for a waiver. Yes, Anahi, thank you very much for actually mentioning that. It is true, you can definitely apply for a medical waiver. Actually, I do have a video on applying for a medical waiver. I'm pretty sure I do have it on this channel. Unfortunately, however, most of the times these waivers are denied. Most of the time the applications are based on religious beliefs, and whenever it comes to religious beliefs, unfortunately there is really not much that you can prove. I mean, you can get a letter from your pastor, your mullah, or whoever you're in the church or in the mosque where you go to, or whatever it is, the organ. But the problem is, for example, I don't go to the church, I don't go to the mosque, and I believe in God. So how do I prove that, that I don't believe in all of this kind of stuff? I believe in God and God's healing powers and, protective over me. I can't. So that's where the problem kind of comes into play whenever it comes to the waiver. And yes, I've personally tried to do that, and my waiver was denied. Yes, I've tried to do the medical waiver. So yes, thank you for letting everyone know there is a waiver. But also, everyone, keep in mind that a lot of times it doesn't work, and a lot of times you can't even do anything about it. Okay, let's move on to the next question and comment from Oracle. Oracle, thank you for another comment. Appreciate it. Hello, thanks for everything. You asked how long NVC took to documentarily qualify my wife and kids. It took 2 weeks for NVC to approve it for them, my younger kids. I filed for I-864W for them, and I-864 for my wife and older daughter, but NVC has only approved for my 2 young kids and my wife. My eldest daughter is still not approved. I want to know what the issue is since I use the same documents for all of them. NVC messaged me to send civil and financial documents with WIS for DS-260. I did submit all these documents when I submitted for all of them. On my daughter's CAC account, everything shows submitted though, so still don't know why she has not been documentarily qualified. Thanks again. Oracle, honestly, I don't think there is any issue whatsoever. I think the 2 weeks, they reviewed in 2 weeks, your wife and younger kids, is extremely fast. I've never seen anyone being documentarily qualified in 2 weeks. So congratulations on that. I think everything is good. Personally, it took 6 months for, my personal to become documentarily qualified, just for your information. So I don't think there is any problem at all. But if you want, for your peace of mind, submit the public inquiry to the NVC and say, hey guys, my wife and my younger kids are already documentarily qualified. They're their cases were reviewed, their documents were reviewed within 2 weeks, and my older daughter, she's, you know, her documents are still not reviewed. So I was wondering, you know, what's going on, and I just wanted to follow up. Submit a public inquiry like this and see what they respond. I'm gonna actually post this public inquiry form. I'm pretty sure you already have it because I think I already gave it to you, but I'll post this link in my response and see what they say. But honestly, I don't think there's any problems at all, because it's just those three, you know, portals were reviewed really quickly, because most of the times it takes about 3 months for them to review it, and in your situation it was really quick. But again, for your peace of mind, go ahead, submit it, and see what they say. So thank you very much everyone for tuning in today for this video. If you have any follow-up comments, do not hesitate to ask them. Just make sure you don't post your follow-up comment or question in a response to my comment in your comment, because YouTube does not send me those notifications. Please submit it as a separate comment on any of the videos, and it will show up here on this wall. Again, thank you for watching. God bless, and I will see you all in the next video.